Hello, my name is Vedant. I am a legal intern with LEXIS and Company. Before starting of the video, I would like to say that please like and share the videos and subscribe to the YouTube channel of LEXIS and Company. There is a small disclaimer as per the guidelines of the Bar Council of India. The videos of this channel does not promote or advertise anything about the company, and these videos are only for educational purposes for the audiences. So today's topic of the video is the continuation of what we have discussed in yesterday's video, that is the Hague Evidence Convention and India with respect to India. So the word evidence cannot be narrowly construed, ignoring the meaning and definition of the term evidence under the Indian Evidence Act. There is no provision in the CPC that would limit or not permit documentary evidence to be obtained at the behest and request of a foreign court under Order 26 Rule 19 read with Section 78 of CPC. There is an inherent contradiction within Order 26 Rule 19 of the CPC 1908, which widens the scope of evidence that can be obtained under the above mentioned rule. Rule 19 uses the phrase High Court may issue to examine witnesses and wishes to obtain evidence of witness. When two interpretations are possible, the more liberal interpretation, which is in consonance with the Hague Convention, needs to be adhered to. So there is a question that can a request for inspection of a property by a foreign court be granted under Indian law? Can it be possible? So Article 3 Clause G of the Hague Convention states that a letter of request may specify the documents or the property to be inspected. The convention does not define the term inspection. However, inspection of documents or property has to be understood and read along with Article 1 of the convention. The inspection has to be for the purpose of obtaining evidence which the judicial authority of a contracting state has requested the competent authority of another contracting state. Article 1 of the convention also uses the phrase perform some other judicial act which would include inspection or investigation of a local property in India within the jurisdiction of the Commission. Therefore, if inspection of a property is requested for the purpose of taking of evidence, there is no restriction or bar on granting or allowing such inspection under the CPC. Section 75 of CPC lays down the power of a court to issue commissions. Order 26, Rule 16 of CPC provides for powers of commissioner to be exercised under Order 26 of the CPC. Section 75 Clause B clearly states that a commission may be issued to make a local investigation. Therefore, this provision will apply irrespective of the fact whether the commission has been issued by a court in India or based on a letter of request issued by a foreign court under the convention. Similarly, Rule 16 confers the power to call for and examine documents and undertake inspection, etc. of a property upon any commissioner who is appointed under Order 26 of CPC. Therefore, a commission issued by a High Court under Order 26 Rule 19 of CPC would also have the powers as provided under Order 26 Rule 16 of CPC. It would be fair to conclude that the High Court, in exercise of its power under Order 26 Rule 19 read with Section 75 and 78 of the CPC, can issue a commission on request of a foreign court to obtain both oral as well as documentary evidence, and also permit inspection of documents and property within the jurisdictional limit of such high court or commission. So what are the important judgments with respect to such request by a foreign court? There are two important judgments of Delhi High Court dated in year 2009 in the matter between Unpaid Systems Limited versus Satyam Computer and Services, and Gujarat High Court or judgment in 2020 in the matter of Carnegie Institute of Washington versus Phoenix Diamonds LLC, respectively, that governs the execution and implementation of letter of request issued by a foreign court under the convention. The findings in the two decisions are interesting since the Gujarat High Court in the matter of Carnage Institute takes a more contracted view of Order 26 Rule 19 read with Section 78 of the CPC. The Gujarat High Court holds that in execution of a letter of request issued by a foreign court under the convention, a commission appointed or issued under Order 26 Rule 19 of the CPC would be confined only to obtain oral evidence or testimony of the witness and not for any other such purposes such as production of documents, inspection or investigation of property. In the matter of unpaid systems before Delhi High Court, two requests were made in the letter of request received from the United States Court of District for Eastern District of Texas, Marshall Division for recording deposition of witnesses and for production of documents. Two questions were framed by Delhi High Court. First was whether in absence of a municipal law specially enacted to facilitate obligation under the convention, can the High Court appoint a commissioner to execute the letter of request received from a foreign court under the convention. The court rightly answered the question and held that when there is an enabling provision and law in the CPC empowering the High Court to issue a commission for the purpose of obtaining evidence on the basis of letter of request issued by a foreign court, an absence of specific or special law for implementation of the convention is not a necessity or a requirement. The second question with respect to the production of documents is answered by Delhi High Court. The High Court held that the expression evidence used in Rule 19 is sufficiently wide enough to comprehend oral as well as documentary evidence. Therefore, a High Court can issue a commission under Order 26 Rule 19 of CPC for obtaining both oral as well as documentary evidence. So, in contra, the Gujarat High Court interprets Order 26 Rule 19 of CPC to hold that a commission can be issued under Order 26 Rule 19 only for oral examination of witnesses and not for any other purpose, while in contrast, Delhi High Court interprets that the term evidence on a wide compass and interprets that it includes both oral as well as documentary evidence which can be examined or inspected on the letter of request by a foreign court. However, Delhi High Court held that had no occasion to rule on the issue of inspection or investigation of property, and the view of the Gujarat High Court, unless reserved, would prevail. None of the decisions have been tested and challenged before the Honorable Supreme Court. So this was about the Hague Convention and the judicial decisions that were decided by Indian High Courts. Thank you. Do like and share the videos and subscribe to the YouTube channel of LEXIS and Company.